Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 191 of the NCDWI Guy podcast. We are here less than a week out from Christmas, and we have just, as a defense bar, been given a Christmas gift by the North Carolina Court of Appeals. Hot off the press, State versus C.K.D, initials C.K.D. Ultimately, after dismissal in Superior Court, this case was expunged. So the defendant in this matter is identified only by initials. But State versus C.K.D, this is an unpublished opinion. So the Court of Appeals did not give us a wrapped gift. It was unwrapped. But nonetheless, whenever you get a gift from the Court of Appeals as a defense lawyer, you absolutely take that gift, relish it, and utilize it. And so this is a Knoll case. This is a case in Knoll, and the motion to dismiss based on State versus Knoll that was granted in Superior Court was upheld by the North Carolina Court of Appeals. Knoll has been an interesting part of my practice because the first case that I ever won, the first DWI that I ever had dismissed at trial, was dismissed by a Knoll dismissal. And I have heard it said in a number of counties that I've practiced in that Knoll is dead, that it doesn't have teeth. I have other attorneys that have routinely made challenges successfully in district and Superior Court based on Knoll. There have been a number of challenges by our attorneys here at the office recently that I have seen as successful Knoll challenges, and there's a number of reasons for that. I think that there has been some typically speaking, whenever you've got a Knoll violation, there is something going on in terms of the magistrate not filling out paperwork appropriately or following the proper procedures for release. So sometimes it could be based on poor training of magistrates. Sometimes it can be based on a local policy that is enacted. But whatever the case may be, I think that the decision in State versus C.K.D, albeit unpublished, is affirmation that Knoll is alive and well here at the end of 2023. That at this moment in time, Knoll is alive and well. And if you get a chance, this is a case to take a deep dive into it because the facts are just so wonderful for the defense. I mean, they're just, in terms of future motions to dismiss based on Knoll, the facts in this case are incredibly helpful. And you might say, well, why is that? Like, why are these facts so incredibly helpful? It's because they are similar to the facts in Hicks, one of the three Knoll cases, as the court in C.K.D points out. But I think it's a reminder of how great for the defense the Knoll cases factually are. I mean, they're just great cases. I mean, really, it's one of those things where you read Knoll, the Knoll cases, and you're like, why are we not, as a defense bar, challenging based on this routinely? And so you read the facts of C.K.D, and you're like, man, these are just such incredible facts. I see this kind of stuff all the time in practice. And yet the real reason that the court decides the way it does in C.K.D. is it says this is basically an identical situation to Hicks in the Knoll original line of cases. So, this is just one worth really taking a look at and diving into. Now, if you want a deeper dive into State versus Knoll, go back and listen to episode 55, which is specific to State versus Knoll and the cases that are looked at by the Supreme Court in State versus Knoll. And then episode 56, I had a conversation with attorney Nathan Earwood on utilizing the principles of State versus Knoll in making motions to dismiss in DWI cases. So when you're actually trying to use this more recent case, unpublished case of State versus C.K.D. in determining a potential Knoll issue, go take a listen to episodes 55 and 56. But I'm just going to read a little bit from the background section of the State versus C.K.D. Case to give you a little bit of background. This was a Iredell County case. Mooresville Police Department officer arrests the defendant for driving while impaired. The defendant registered a 0.17 breath alcohol concentration. Defendant was transported to the Iredell County Magistrate's office, where Magistrate Holler set a $2,500 unsecured bond and detained defendant until 1, his physical or mental faculties are no longer impaired to the extent he presented a danger, or 2, a release to a sober, responsible adult who is willing to assume responsibility for him. In the detention form, the magistrate found by clear and convincing evidence that the defendant's condition of BAC 0.17, red glassy eyes, slurred speech, odor of alcohol presented a danger of physical injury to the defendant or others, or damage to property if he were released. So those are kind of some of the main facts. A couple of other very critical facts in terms of, I think these are extremely helpful to the defendant in future motions to dismiss based on Knoll, if you are trying to point the court to State versus C.K.D., this unpublished opinion. In this case, when the defendant was arrested, he was provided the opportunity to use a phone, but declined because he did not want to wake up his wife and young children. So he was given the opportunity at the point of arrest to use a phone, didn't want to wake up his wife and kids. Moreover, defendant also signed a document titled Implied Consent Offense Notice, which gave defendant the opportunity to list contact information for individuals he wished to contact. But he checked the box indicating, I do not wish to contact anyone for the purposes of observing me at jail or administering an additional chemical analysis. So that checkbox, I would say that that's one of those things where in a lot of cases, that to me is where the state says, puts it all in and says, hey, the defendant did not want to contact a witness, didn't want to have an independent test done. Despite not attempting to call home because he didn't want to wake his wife and the kids, despite checking the box that he did not wish to have a witness come to see him at the jail or to have an independent test run, the court says the Superior Court made the right call when they made when it granted the defendant's motion to dismiss. And this is just a massively helpful opinion. The court did acknowledge that the prejudice in this case was not assumed, because under 20-138.182, the fact that there was a breath sample of 0.08 or greater provided basically means that prejudice was not to be assumed in this case, that the defendant had to prove prejudice due to the 0.17 that existed in this charge. And the court said, yes, that there has been a showing by the defendant of prejudice in this particular case. The court, in making its decision, really, again, drew a clear comparison to the facts in Hicks. Basically, it said this is ultimately one of the main reasons that it ruled in this particular way. Again, let's see, I'm turning to page 8 of the order here. The facts here are strikingly similar to the defendant Hicks in Knoll. The state has not challenged any of the trial court's findings of fact, and this court and the state are bound by those findings. Like in Knoll, the trial court here found the defendant was all times polite and cooperative. There was no evidence offered to the court that the defendant had created a disturbance or would do so if released. Just to the contrary, the magistrate's written findings on AOC CR 270 were BAC .17, red glassy eyes, slurred speech, odor of alcohol, and no other evidence was offered to support the conclusion by clear and convincing evidence that the defendant's level of impairment was such that his release on unsecured bond would present a danger of physical injury to him or damage to property. These findings of fact were sufficient to support the conclusions that defendant Hicks was not a threat and should have been released, and they are sufficient to support the trial court's conclusions here. One of the things that really stands out is that the magistrate did fill out a findings of fact form that basically was saying that the defendant presents a danger to himself or others based on the following signs of impairment. And in this C.K.D. case, again, the magistrate specifically put onto that form the BAC was .17, red glassy eyes, slurred speech, odor of alcohol. What the court in C.K.D. says is, okay, that's enough to show probable cause to arrest somebody for driving while impaired, but that in and of itself does not show that the defendant creates a danger to himself or to the community. And the state specifically argued in this case, well, the .17 alone is enough to support a presumption that somebody is going to present a danger to themselves or to the community. And the Court of Appeals in State versus C.K.D. Utterly rejects that argument. It says, no, I mean, if you look at the Knoll cases, all of those situations involve defendants with extremely high BAC levels. Hicks in particular had the same kind of factual scenario in terms of BAC. So that's not enough. So it's not enough for the magistrate to put in there as a reason for holding somebody just the BAC, and in this case, red glassy eyes, slurred speech, and odor of alcohol. That wasn't enough to show by clear and convincing evidence that the defendant presented a danger to themselves or to another person if released. That didn't meet that clear and convincing threshold. So that's incredibly important if you have a situation. I've seen a lot of times where the magistrate has not even filled out that detention of impaired driver form, and that's its own set of problems. But even if you have a magistrate that does fill out that detention of impaired driver form, this is a situation where that in and of itself does not mean that the standard for showing that the person is a danger to themselves or others by clear and convincing evidence has been met. Again, the court repeatedly point out that the defendant in this case was polite and cooperative, that there was no indication that they were causing a ruckus or disturbance at the jail. And so again, just pointing out that what the court, I think, concluded were obvious, or here it is, classic signs of impairment. Just because the magistrate pointed out classic signs of impairment does not mean that the detention of impaired driver form had shown by clear and convincing evidence that the defendant was a danger to himself or to others. So that is incredibly important. The court pointed out that the defendant in this case had funds on his person to pay for a taxi or Uber ride. and that he would have been back in the presence of his wife within 25 to 30 minutes if in fact he had been released and allowed to go get a Uber. The state also, again, harped on this fact that the defendant had waived his rights to contest a violation under Knoll because he had checked a box on the implied consent offense notice form that said, "I do not wish to contact anyone for the purposes of observing me at the jail or administering an additional chemical analysis." The court said it doesn't matter that he signed that form and checked that box. The court said, quote, "Even if defendant waived his right to have someone observe him at the jail, he did not waive his right to have friends or family observe his condition outside the jail, which is what would have occurred had he been permitted to call a taxi and return home to his wife," end quote. Boom. That is a huge statement in terms of making future Knoll arguments. Because if you have a form where it's not clear, again, in this case, the state was able to show he had the opportunity to call home. He didn't do that because he didn't want to wake up his wife and kids. He had the opportunity to indicate that he wanted someone to observe him at the jail. He specifically stated he didn't want somebody to come observe him at the jail. And the court says, doesn't matter. The violation is that he would have had the opportunity to have outsiders, people outside the jail, observe him had he been released. There wasn't a justification by clear and convincing evidence that he presented a danger to himself or the community. If he had been released, he would have had the opportunity to get a taxi. He had the monies to get a taxi. And so holding him for 11 hours, and the court pointed out that there was only one test that was done, breath test that was done during that 11-hour period prior to his release to kind of check where his alcohol concentration was, that there was that was too long a period of time, and that the defendant had in fact shown, proven prejudice requiring a dismissal of the case pursuant to State versus Knoll. So again, this is a case that if you have a Knoll situation, if you have somebody that was held at the jail for a long period of time, take a real hard and close look at that detention of impaired driver form. It's not a slam dunk for the case if the defendant on the implied consent offense notice has checked the box indicating that they do not wish somebody to come and observe them at the jail. There is a lot in play in terms of taking these violations forward. And again, as wonderful a decision as this is for the defense, it's really kind of sad, honestly, that this is like such a victory, because it really just spells out again what the Supreme Court of the state of North Carolina said decades ago in State versus Knoll, which is that in these type of situations, evidence that a defendant could use to prove sobriety is fleeting. Evidence that the defendant could use to prove sobriety is fleeting. It looks as though the Superior Court, so the Superior Court really put a emphasis on this fact in its conclusions of law. In the Superior Court order, one of the conclusions was, as originally stated in the Knoll decision, to assume that the defendant's lost opportunity to gather evidence on his behalf was not prejudicial is to assume that which is incapable of proof. The court cannot assume the infallibility and credibility of the state's witnesses or the certitude of their tests. If a defendant is not released to have the opportunity to gather evidence, to be in front of another person, another witness that can talk about their sobriety, to get their own independent tests, there's not a level playing field. You're 100% relying on what the state has the ability to present at trial. And that's why this timely release issue is so crucial. It's why it is such a big deal that it can result in a dismissal of charges if the release does not occur in a timely fashion. So go check out the gift received from the Court of Appeals this week before Christmas, State versus C.K.D. Do a deep dive, really chew into the facts of C.K.D. so you can think about how you might be able to use that argument in your own case. And definitely go back and reread Knoll in light of C.K.D. Get after it. Jump into 2024 ready to push some Knoll issues. Look forward to speaking with you next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.